see have resolved themselves, and some of the cases that we thought we were going to see have been postponed. So, on the true crime front, the trial front, it's kind of quiet out there. So, I originally thought that maybe I'd give everybody a refresher on criminal law and criminal procedure, and we'd talk about indictments and probable cause and all those kind of things. But we've kind of done that before. And I started thinking about what is in the headlines these days, and the issue of free speech and the issue of defamation and what are called anti slap legislation is kind of right out in the forefront right now. So I thought we might depart from our usual true crime roundups, and we might talk a bit about free speech and defamation. Now, y'all know, anybody who follows me know, I love me the Constitution. I've always loved studying it, and I've loved what it means, and I've loved how it is the underpinning of our system. Um, it was my favorite subject in law school, and I have an undergraduate degree in journalism, so free speech has always been a little bit of a pet subject of mine. So I thought maybe we'd take some time and talk about that today, and talk about what it is that free speech is and what it isn't, and what happens when someone files a defamation suit, and how is your speech protected against those sort of frivolous defamation suits. And I guess it's really topical considering the the environment, the online environment in general. You know, we really have moved beyond the point where we have what now we call legacy media, the big newspapers and the big TV stations. And we've moved into an era where anybody with a microphone is a journalist. I think a classic example of that is the Karen Reed case in Massachusetts, and the guy Aiden Carney, who calls himself Turtle Boy. Now, Turtle Boy isn't really what we would consider by societal standards, by old standards, a journalist. But he is a guy with a YouTube channel, a sizable following, and a microphone, and a point of view. And I guess that's all it really takes is a microphone and a point of view, which is why you come to see me, I guess, because I have a microphone and a point of view. So, um, but as we have had more and more true crime, more and more creators in general, not just true crime creators, but more and more creators in general, we see those lines blur a bit. Um, there was a time, certainly when I was going to college and studying journalism, there was a code of ethics. There was a canon of ethics that all of the major journalism schools and all of the major professional organizations subscribed to. They believed in a set of journalistic ethics. Now, was it as subscribed as the ethics for lawyers? No, because there wasn't there isn't still, especially an enforcement mechanism. So there's no mechanism to enforce the canons of ethics that journalists typically say that they work under. If they violate those ethics, there's no mechanism to punish them. But a lot of journalism schools, all of the major journalism schools, have right in their curriculum that it is their intention that they teach and that their students abide by a canon of ethics. It's a little bit different in the legal field because in the law, there are state bar organizations and licensing organizations that hold lawyers accountable for violations of those ethical canons, those ethical requirements. They are codified, and because we're licensed, there is a mechanism by which we can be held accountable if, in fact, we violate those ethical obligations. So, we always have to balance free speech and the right to say um, things that are not particularly popular or things that other people might find objectionable. We need to balance that right to free speech with where it begins to impact other people. So the US Supreme Court has always been very, even the more conservative courts have always been very careful about protecting the First Amendment right to free speech. So I just want to take a minute and talk and read you what the First Amendment says. You know, a lot of people talk about the First Amendment, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, but we don't always know what the actual language is. What do they really say? So, this is the entirety of the First Amendment. And it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, I think there is a reason that the founding fathers put all of those things in one amendment. There isn't a separate amendment about religion. There isn't a separate amendment about freedom of assembly. It's all in one place. And I think there's a reason for that. The founding fathers did very little without thinking it very thoroughly through. So the reason why all these things are in the same amendment, religion and speech and the press and assembly and petition the government for grievances. If you think about it, these are all examples of free speech. The right um, to worship as you choose is separated into two parts, which it's always important to think about. First, the government cannot establish a religion. We don't have an American religion. We don't have a Church of America the way that there's a Church of England. We don't have an entity which is the chosen faith of choice for the American people. The second thing is they can't prohibit the free exercise of religion. So on one side, they say it guarantees the freedom from religion, meaning that you don't have to be any religion at all. And there is no mandatory state religion that you're expected to participate in. On the flip side, you can't be prohibited from exercising your free beliefs, your free right to believe as you choose. This came up when we were talking about the Delphi murders and the fact that there were some suggestions in the crime scene that the Norse pagan religion known as Odinism was somehow involved, or that people who believed that were somehow involved. And one of the things that we discovered is that the prisons were not precluded, were required to recognize Odinism and its white supremacist underpinnings as a recognized and practiced religion in the prisons. They were required to set aside time for people to do rituals. They're called blots. They were required to allow people to wear religious insignias, Thor's hammer, and they were required to um, recognize and make room for that, the same as they did for any other religion that was being practiced in the prison. That was required by the Supreme Court. So you can see that these ideas are really intertwined. It is a matter of the freedom of speech. Likewise, we have freedom of speech and freedom of the press. Freedom of the press is important because the people need to know what their government is doing, what the world around is happening in the world around them before they have the ability to speak out against it or to support it. They need to know what's happening. So the press is a vital part, often called the fourth part of government, the fourth chamber. So it's important to understand that all of those things are interwoven. The right to assemble, well, the right to get into a group and then talk about what you think. Talk about what's going on in your world, in the government. What are people doing? The right to address and address grievances to the government and petition for redress, meaning I want you to make this right. I'm sorry. Struggling with it tonight. So, meaning going back to the government and saying, I want you to make this right. And I want you to change the rules. I want you to I want you to change how the government deals with people of color or with women or with children. I want you to I want you to hear my complaint and address it. So freedom of speech is so important that there are literally hundreds of court decisions interpreting what we just read in the First Amendment. And they go all the way from state courts to the federal court and, of course, to the U.S. Supreme Court. And there are many, many decisions that have been made by the U.S. Supreme Court. Now we come to the point where we also have all this unregulated airwaves. For a very long time, the Federal Communications Commission really controlled the airwaves. They controlled TV and radio, and so you had to get a license from the federal government in order to operate. That's not the case now. Anybody with a microphone and an opinion and a Wi-Fi signal can sit down and put something out over the airwaves. And it really is the Wild West. It really is the place where there are many, many competing opinions and many, many conflicts over competing opinions. So one of the ways that a citizen, now, the First Amendment is, for the most part, intended to protect people from their government interfering with their right to free speech. So many of the Supreme Court decisions have to do with government agencies or employers limiting people's free speech. But all of those decisions also apply to private citizens. So what happens if somebody says something about you that you don't like? What's the remedy? What's your recourse? If someone says something publicly on the internet about you that you don't like? Well, the recourse is a civil suit for defamation of character. And there are two different forms of defamation. There's primarily what we talk about is libel, because libel is when something is made public and is distributed publicly. So let's say that you decide that something someone has said about you hurt your feelings or offended you. Can you sue them? Well, the short answer is you can, but if you are suing them, it must be because what they said isn't true. So when somebody put a meme out at Halloween of me and made fun of me for my voluminous eyelashes, that's not defamatory. First of all, it was true. But secondly, it's not defamatory speech. The reason why defamation is a very high bar, a steep hill to climb, is because of our veneration and our respect for the right of free speech and the First Amendment. So typically what happens is someone files a claim, files a lawsuit, a civil suit, asking for damages, that's money, against someone who they believe has has defamed them. Now what happens? Well, in this era of it being the Wild West out here, we have what are known as anti-slap laws. So let's say that I'm mad at somebody for making fun of my eyelashes, and I decide that that's defamatory and I sue them. There are mechanisms within just about every state, as far as I know, for what are called anti-slap motions. What that means is that the person who the suit has been filed against says, this was done as an exercise of my right of free speech related to an issue of public interest. Well, I don't know whether my eyelashes are public interest or not, but when I put myself out on the airwaves, they're fair game. So anti-slap legislation has come about very much because of this Wild West mentality. Now, I don't know if any of you have been following a lot of these other creators. There's a woman out there called Bullhorn Betty, and she has been the target of a bunch of suits, and there have been a defamation suit filed against somebody else, and I don't know that much about it, but it's a whole thing. it is the epitome of the true crime community's dirty laundry. So one of the suits against her has to do with the fact that she followed people around and confronted them, including following them around in her car, banging on their car windows. So moving well beyond just being a person with a microphone to harassing and stalking someone. And these are the kinds of things that defamation and stalking orders were designed to combat, both of which have been filed apparently against this person. But truthfully, in a defamation suit, truth is an absolute defense. It isn't defamation if it's true. So if I come on here and I say about another creator, that creator got a hold of an advanced copy of my manuscript and sent it out to her followers to undermine my success with my book, and I can prove that that is true, it's not defamation. It's not defamation if someone says something on the internet that hurts your feelings. It's not defamation, and it's not stalking either. So the anti-slap laws have come into being in most states because of the problem of so many frivolous defamation suits. So most statutes, and I'm just looking at the one from my home state, Oregon, and it basically says that the person who the suit was filed against is allowed to file a motion to strike any civil action if the action is being asserted based on oral statements made or written statements or other documents presented in a place open to the public or a public forum in connection with an issue of public interest. So it is much easier these days for online creators to be able to slap down these frivolous suits for defamation based on the fact that the conduct is protected free speech. And one of the things that some of the writing says about the Oregon statute is it says the activities that are protected by this are oral or written statements made in a public forum in connection with an issue of public interest, as well as any other exercise of the right of speech related to an issue of public interest. The courts looked to make sure that what they said was it's the conduct, the speech that is targeted, and an act in furtherance of that protected activity is also protected. So you can see that we have a long history of protecting free speech. Getting on television and saying mistakenly that a shooter was not a left-leaning lunatic isn't defamation. Getting on to and particularly when you're talking about public figures. So if the person is a public figure, like somebody who has 317,000 YouTube followers, that person in order to bring a defamation suit, not only do they have to prove that what the person has said isn't true, but they also have to prove that that person acted with actual malice toward them. And that is a really high bar. Additionally, in a lot of jurisdictions, you must prove that not just by a preponderance of the evidence, not just 51%, but clear and convincing evidence, that 75% mark. So this is a very difficult thing to prove. But we see a few of these creators who are misusing law enforcement, misusing lawsuits, and misusing restraining orders, stalking orders, in order to go after people that they don't, when they don't like what those people say. So, was it defamation for Jimmy Kimmel to say the things that he says? No, it's protected speech. And satire is a very almost sacred kind of speech. Satire is the heart of political speech. So someone who is satirizing anything is going to have a lot of leeway in a defamation suit. So comedy, satire, that's protected speech. Standing up on the street corner and yelling that you hate the president, protected speech. Standing on the street corner and yelling that you don't like a particular YouTube creator, protected speech. Walking around at CrimeCon and telling people a particular YouTube creator is a problem, protected speech. All of those things are protected, and thank goodness they are, because our democracy is founded on the people being able to speak their minds and being able to say what they think about their government or the people who are in it. The minute that we start limiting what people can say about public figures, and particularly political figures, we run the risk of becoming Russia, becoming countries where speech can get you arrested, like Iran, like Russia, like North Korea. I don't think any of us want to go there. So, yeah, from time to time, somebody is going to make fun of my eyelashes, or somebody's going to say something about me that I don't like, or that hurts my feelings, or that makes me feel bad. But that's the price we pay for the freedoms we enjoy. That's the price I pay for having a microphone and something to talk about. It's the price we all pay for living in a democracy where we're not only allowed, but we're expected to express our opinions and to discuss diverse opinions and to participate in the spirited exchange of ideas. So they can post stuff about my eyelashes or whatever else they want to post about. And I'll keep coming here with my opinion and my microphone, and I'll respect that there are other opinions and other microphones, and you all get to choose. Sometimes we need to choose wisely. Sometimes we need to think about where we're putting our attention and where we're putting our money. But it's up to all of us as individuals to decide that. Like I say, there's not a lot going on in the true crime world. There was a little bit of an interesting thing to talk about, and that was in the Long Island serial killer case. So y'all might remember, because we've talked about this a lot, whenever there is a new or improved technology, every state is responsible at the state court level for deciding whether or not that technology meets the standards that were set out in the Supreme Court case called Daubert. And that basically is this technology widely accepted, and is it defensible? Can you repeat the results? Can you apply the technology more than once and get the same result? Really just looking at the basics of scientific technology. So one of the things that has happened is, for a very long time, we've done DNA. Now, I'm not a DNA expert, so I'm making this as simple as I make it for myself. But the technology that we had, the nuclear DNA technology, required a certain concentration of DNA, and there were other processes that were less reliable. Well, within the last 5 years or so, there has developed, and it developed out of labs trying to get DNA out of hair shafts that did not have cells, did not have root cells at the end. And they came up with a different process, and they call it a SNP. And in doing so, they have been able to identify, at a minimum, mitochondrial DNA, which is the matrilineal line, the mother's line, and able to they have been able to identify more clearly people through that. So what that has meant is that there have been a lot more applications of that, applications of genetic genealogy to that SNP process, because it brings up more alternatives. At least this is the way I understand it. So in each state, the court has, and in each trial, the court has to decide whether or not that judge will allow that technology in for that trial. We saw this with the Lori Vallow trial. The judge decided to let in the analysis of the hairs that were found in the tape that was around J.J. Vallow. And the hair turned out to belong to Lori Vallow. Now, we know that hair gets shed, so the only thing we really know is that at some point she was in contact potentially with the area where his body was wrapped, or it came off of him. So the thing to remember is that that's just the beginning of trying to connect up. So what happened in Rex Heuermann's case is that on a couple of the bodies that they were discovered, they found that were wrapped in burlap, they found hairs. And while those hairs didn't match Rex Heuermann, they matched the women in his life. They matched his daughter, his wife, and in fact, his first wife. So they were all a way of connecting him up to the scene. Now, um, because this is fairly new technology, this SNP technology, um, every judge has to make a decision about whether or not they're going to admit it, whether it meets the Daubert and Frye standards. And so just recently, the judge in the Long Island serial killer case issued two rulings. One was to allow that DNA to come in, which is very important. And the other was denied the motion by the defense to separate all those cases, to sever those cases. And I think that's going to be important for the prosecution, because they're going to be able to sort of use each one of those discoveries as a stepping stone toward Rex Heuermann. Each one of them individually may not be as big a connection. The other thing that they have is they have this Word document that appears to be sort of a how-to or a to-do list. And by being able to keep all of those cases together, they're able to relate some of the things that are in that document to the specific locations of some of the victims' bodies. So there's that. That happened today or this week. But for the most part, it's been very quiet out there. There aren't a lot of trials going on. We do know that in Massachusetts, they just did a big motion hearing on Aidan Carney's charges. And there is some rumor floating around out there that his charges may be dismissed. Also interesting is the special prosecutor who was appointed to prosecute Agent Aidan Carney just asked to withdraw and said that he had a conflict that he could not waive, that was unwaivable. So that's kind of interesting. But there's so much going on involved in that case. I mean, there's so much. That's still swirling around out there. Michael Proctor still hasn't finished his hearing on whether or not to be reinstated to the state police. Highly doubt that's going to happen. And of course, there are all sorts of discovery motions out there on Brian Walsh and several other cases right now, because everybody wants the files from Karen Reed's case having to do with Michael Proctor and his text messages and all of that vile stuff. And they all want it. And in those cases, Michael Proctor was the lead investigator on them. Sandra Birchmore. Now, Birchmore's case is a federal case, so it is not being litigated. The issue of his text messages are not being litigated in state court. But Brian Walsh and a couple of other criminal cases, one, I think the last name is King, they're all still fighting over whether or not they can get that, and whether or not the protective order that the federal government put in place precludes the prosecutor from giving the defense that information. And I'm telling you what, the prosecutor is putting up every roadblock they possibly can. They get to court and they're like, oh, we can't even talk about that in open court because of the federal judge's gag order. And the judge is getting a little bit impatient with the fact that the prosecutor is hiding behind this federal judge's gag order and not producing what needs to be produced. So there's that going on, and that's going to go on forever. Other than that, Chad Daybell is still sending letters from prison. If you want a real rundown on those, you can go and take a look at Profiling Evil. He has been giving a rundown on those letters. They're very self-serving. They're very much focused on, I want you all to know that I'm a good guy. He does not in any way take responsibility for his actions, does not take any sort of accountability, and does not ever mention Lori Vallow. He just sort of glosses over that. He talks about one of the letters talked at length about Tammy, about how much he loved her, yada, yada. But he doesn't at any point accept responsibility. And they're really devoid of any real value. But it is interesting to hear them analyzed from a profiling standpoint. So you can do that. And yes, that those letters are being distributed on Twitter thanks to Emma, who has Chad Daybell's daughter, Emma Murray, who has set up a Twitter account so that she can distribute his letters and get the truth out to everyone that he's really not guilty. So there you go. You know, there's just not a huge amount to talk about, but I would love to hear what you'd like to talk about if you have questions. So while we're doing that, please, while Jen is looking for questions, please like and subscribe. If you're new to the channel, I forgot to sort of introduce myself. I'm a retired criminal lawyer. I did both prosecution and defense during my almost 30-year career. And I'm here to talk about the law and where true crime and the law intersect. So we try to take things as in as factual a position as we possibly can. And we try to explain sometimes all of the ins and outs of these criminal cases, because sometimes it can be downright mystifying trying to understand why procedurally things happen the way they do. So I'm here for you, and we're here to talk about it. Hi, Jane Blackbird. This is a good question. Well, you might remember in the Reed case that the FBI got involved and was investigating, because it is often their job to investigate the investigators. And the Birchmore case involved several police officers, and it- they they were accused of having groomed Sandra Birchmore when she was very young. I think she became an Explorer Scout at about age 13 or 14. By 15, they were had groomed her for SA, and literally were passing her around to 2 or 3 men, including Matthew Farwell, who is the accused murderer, and his brother. So not great people. And when it is necessary to investigate law enforcement, generally the federal government gets involved. In this case, the police investigation swept it under the rug, thanks in part to Officer Tully and all the usual Canton suspects, Michael Proctor, and all the usual state police suspects, Michael Proctor, Tully, Buchanan. So because of that, the feds got involved in investigating the investigators. And when they found probable cause to believe that Sandra Birchmore had been murdered and had not, in fact, self-eliminated, at that point, the federal government came in and charged him with federal murder charges. And that often happens when police officers are involved or law enforcement departments are involved. So, good question. Hi, Ladybug Lady. Let's see, we're getting on to fall, so I bet your ladybugs are getting ready to go to sleep. Question, could the letters from Chad have any impact on his appeal process? Not really. Not really, because the appeals are all based on what was brought in at trial, and really appeals are decided on the four corners of the trial below. So it's not going to impact. I mean, even if he were to write a confessional letter at this point, it would not have an impact on his appeals. So the appeals are really basically on the procedure, what happened, whether the judge made mistakes at the trial court level. And so it's not going to have much effect. But I'm sorry that he has a forum at this point. And it does appear from some of the letters that he talks about, people have been writing him and supporting him. So it does appear that he still has some friends within the church, which is troubling. I think one of the things that always troubled me was the fact that the church never recognized or said the names of JJ and Tylee, even though they were faithful church members. Tylee did lots of temple work and church work, and had she lived, I'm sure would have done a church mission. And never once did the church speak their names. So, but some people are still supporting Chad. Hi, Deborah. If he's not guilty, Chad should have taken the stand. Well, I don't know. You know, we have a right not to take the stand and risk self-incrimination. Karen Reed didn't take the stand, and I think it's very clear that she wasn't guilty, and a jury found her not guilty. So I don't know that that's 100% like litmus test. But I certainly would have loved to have heard Chad take the stand. It would have been downright amusing. And I am sure that a couple of the prosecutors, Lindsay in particular, would have had a field day with cross-examination. So. Great Laker, Nova Scotia missing children case. Have you read about it? I have read about it. And it's still, I know that they've had cadaver dogs out. I saw that headline today. It's a sad case. I haven't rushed to cover it because it's Nova Scotia and not the US. And I'm not a big expert on the law in Canada. So, but I'm watching it, and if it appears that we're going to have a trial that would be of interest, of course, we'll cover it and I'll watch it. So, but we don't have a lot coming up. A lot of the cases that we had coming up in November and December have been moved. Lindsay Shiver in the Bahamas, several other cases have been bumped out into spring or even next summer. So we're kind of going through a dry spell, which is weird. It seems like true crime. There's always something happening, but it does seem like it's a little bit kind of sparse out there right now. But if anybody has a case that they would like me to take a look at, let me know. including a cold case if if it looks like um, we're not going to get anything too exciting here in the near future. So, Jane Blackbird. I hadn't heard about a first wife of Rex Heuermann. Do you know if she lived in that same house he lives in now when they were married? I don't know that. I do know that he had a first wife, that they were divorced. She's made a couple of brief media statements. She was very clear that she had not had contact with him since they divorced and didn't have any interaction. My understanding is they didn't have children, so they didn't have an ongoing obligation to stay in contact. And so um, uh, uh, I think he had been divorced several years before he married his current wife, Asa. And so, although she's filed for divorce now too. Um, and I don't know whether or not she lived in that same house. Now, my recollection is that he grew up in that house, that it was his mother's home, and that he inherited it after she passed. So there could have been a period of time when he didn't live in that home. Um, that's kind of my understanding, but I don't know for sure. If anybody else knows, drop it in the chat and let us know. Um, why does Lori Daybell get a say in what she pays Kay Woodcock? Shouldn't that be decided by the judge? Hi, Stacy. Well, it is decided by the judge. But let's be honest. Um, Lori Daybell doesn't have anything. Uh, she didn't have a home. All of her homes were rentals. She didn't have much if any, income. Once Charles died, um, she didn't get his life insurance. She collected after JJ and Tylee died for several months worth of Social Security, which undoubtedly she owes repayment on. So she doesn't have anything. Most states require that a certain percentage of any money that gets put on your books or that you earn in a prison job um, goes toward restitution and goes toward your victim. But let's be serious. I mean, she's never going to have any money to give Kay Woodcock. So she's just complaining that what little money she has, she doesn't want Kay to get. It's just sour grapes. Um, so, she's, I think what I understood was she asked for a restitution hearing. Now, what happens in a restitution hearing is that the victims have to actually account for what they're asking for. So, for instance, if Kay is saying, I want restitution for the money I paid for therapy, then she actually has to produce proof that she paid a therapist. She can't just say, I might go to therapy in the future and I want money for it. So some defendants will say, I want the victim to give me receipts. I want them to prove to me that they did these things or that they incurred this cost. And and she has a right to do that. Is it just harassing Kay? Yeah, probably. But Lori has no love for Kay, and I'm sure that she is going to take every opportunity to uh, to make Kay suffer inconvenience. So she's going to fight at every tooth and nail to make sure that Kay is inconvenienced, if nothing else. So I think that's all it is. There's certainly it's not like Idaho has the Slayer statute, so she can't make any money off her crimes, so she isn't writing a book. That's just not she doesn't have any money, she's not gonna get any money. She's gonna be lucky if she gets $60 a month from some nice person who puts money on her books. Um, so I we'll see. Um, but I think that um, it was just going out of her way to inconvenience Kay. Um, so what other questions do you have? Oh, any updates on Corey Richens? The last I heard, her trial has been set out till August, I think. I was looking for my little notes on trial dates, and it is somewhere in the stack on my desk. You know, I'm really grateful that y'all can't see my desk. Because usually it's a mess because there are stacks of stuff everywhere. Things to do, things to take notes on, all those things. And they stack up and then I can't find stuff. So here it is. I found my little notepad where I keep track of all the trials. So we have Teresa and Brittany Collins on for, oh, that's been moved to January. So we don't have anything coming up in October, nothing in November. We have Lindsay Clancy pretrial conference in December and Jennifer Gledhill. January, we finally get to some trials. We have Lindsay Clancy trial, Larry Millette, Corey Richens is set for January 7th. Corey Richens is set for January 7th and 8th for pretrial motions. As far as I know, let me see, her trial starts in late February, February 23rd. So that's what we have going on with her. There's a bunch of pretrial motions set in January. In January, we have Tracy Grist. That's the Rastelli case. Tracy Grist and her son, Kevin Ellis. We have Dee Warner, and we have Teresa and Brittany Collins. The victim was Shannon Collins, and that one actually is a felony fraud case. So that's what's coming up. But right now, October and November look bleak. So we may have more sessions where we deep dive into law because we don't have a lot of cases to dive into. But you never know. Things can change and things can come up. And I would love to hear from all of you if you have other cases that you would like me to follow or like me to look into. So, do you know anything about Barry Morphew? I heard in passing he was released, but haven't researched it. So I think he may have been released on bail. He's got money, and so he, I think, was able to post enough bail to be released. That happened before in his first trial. So the first time the charges were brought against him. But I haven't heard where we're at. I will look that up and we will talk about it next time. Because the last I had heard, he'd been charged and I don't even know if he's been arraigned yet. So let me make a note for next time. Next time, Barry Morphew. What else you want to talk about? Shannon Roberts, $3 million in bail raised largely by supporters. Who boy. Well, that's interesting. Yeah, $3 million. Wow, that's a lot. Um, that's a lot of people kicking in 20 bucks if that's what happened. But does have um, he does have a lot of property. My recollection is that he had a fair amount of property that he could put up for bail. Any idea if Wendy will be charged? Hi, Polly Yo. I feel like we're waiting on this one. Yeah, I feel like we are too. By the way, Polly, I have your email and I will answer it. And thank you for it. Um, I think we're waiting on this one too. And I think it's hard to say. Um, really hard to say. I think that what we have seen is we've seen Georgia Kappelman be incredibly careful and methodical in the way that she's prosecuted all of these cases. So if she is coming for Wendy, I think she's going to take her time and she's going to dot every I and cross every T before she comes after Wendy. Um, uh, every every conviction has sort of raised the likelihood that she might go after Wendy as well. And I hope she does because I think Wendy was involved and I don't think you'll ever convince Georgia Kappelman that she wasn't involved. So I think it's possible, but right now I would give it 50-50. Um, but I do think if it's going to happen, uh, I don't know, maybe next year. I just think Georgia Kappelman is not going to rush. And the other thing is, um, there were a lot of things that were gleaned out of the jail calls between Charlie and Donna after Charlie was convicted that were used against Donna. And so maybe Georgia is just sort of waiting to see what sort of communication is going to come out of Donna being in prison. She may very well be just giving Donna enough rope to hang Wendy. So we'll see. But I think it's 50-50. Hey, want to talk Rawl Valley? That was a wild and sad, chaotic group. Hi, Mary. Um, I have wondered a lot. Is this my Mary Bjornseth? The Mary I know? Rawl Valley, is that the young man who shot somebody at a party? Because we have talked about him before. Um, he claims self-defense. So I'll look into it, but I think that's the case. And we did talk about it when it first happened, but I'd look into it again. It's not as if we don't have time, you know? We don't have a lot of pressing cases to cover. Would you be interested in following the appeal of the Crumbleys in Michigan? You know, this is a case that's interested me from the beginning. The idea that you can hold parents culpable for the actions of their young adult child. Now he was still a minor. He wasn't an adult. He was under 18, but still, um, that case has interested me, and I will look it up because I think that that question, I think it could go all the way to U.S. Supreme Court because I think it really is what the law calls a case of first impression, meaning that there isn't settled law on it yet. So um, that's um, it's interesting because I think we're seeing new law made because of it. So that's a good question. I will look into it. Oh, good. I'm glad, Carol. I'm glad that you enjoyed it. And I'm glad that I can help. And I think that the more we understand our Constitution, the better citizens we can be. So expect more Constitution education from this channel. Oh, wow. Thank you, Jabberday, for offering to send me Jennifer Crumbly's appeal. 100 pages. Yeah, it doesn't surprise me it's 100 pages. She just have laying out the facts would take up 100 pages. Jabberday, are you a lawyer? Seem to remember a comment here recently that I thought, oh, there's another lawyer in the chat. So whether you are or not, welcome. But I would love to see that appeal. You can drop it to me at my email, and that's in the show notes. So, Sam, with the Portland 5 case, did the defendant plead or will we get trial dates? As far as I know, he has not pled. I don't think there's any intention for him to plead. I do believe that they're going to, if they haven't already, seek the death penalty. And so as far as I know, he has not pled. And my understanding is the trial will be in August of 2027. So a year and a half out. So it's been kind of a busy week around here. But I do want to reach out to Melissa Smith, and she's the mom responsible for actually getting the police to investigate. I do want to reach out to her and catch up with her. I met her at CrimeCon. She's amazing, and I love the fact that this is a case in Oregon. So I understand the process. I understand the law in Oregon. It's close enough where I could go over and to Portland and sit in on hearings and trial. So I'm interested in continuing to bring you along with me on that one. uh, I don't anticipate that he's going to plead. And right now, he is accused of 4 murders and potentially another one that is still under investigation that he's connected, that they believe he's connected to. So, what else? Recent arrest in North Carolina of a wife accused of killing her veteran husband and dismembering him. Yeah, I did see that. I did see it, and there are a couple of cases right now. One where the husband was a National Guard member. I'm trying to. We talked about that one last time, I think, or maybe it was the time before. Oh, yeah, that was, Jennifer Gledhill. He was a member of the Utah National Guard. I did see this one, and I'll look into it further. I don't I think it's still early days in that one. So, but I'll look into it. So we'll have some things to talk about next week. Oh, hi, Jackie. Any update on the Karen Reed civil case? Well, in fact, there is. kind of. So during the time that the criminal case was pending, the civil case was stayed, and that's very typical. And now that the criminal case is over, and the civil case is going ahead, things are starting to move again. So Karen Reed's defense filed motions to dismiss some of the wrongful death charges, counts, basically. This is a civil case, so they're not charges, but they're individual counts. So they had a hearing, an argument on whether or not those charges would be dismissed. Now, frankly, it's a very low bar. The motion to dismiss is all they have to do is say, if we assume that everything in this petition is true, does it still not state a basis for relief? So it's very rare that they get thrown out. If they do, they usually just get refiled. But the interesting part about it was that at that hearing, her defense attorneys came in. Now, the people who have sued are the O'Keefe family. They have sued for wrongful death, and they have sued Karen Reed and the Waterfall and C.F. McCarthy's, the two bars. So Karen's attorney came in and said, we want to add a whole bunch of new parties in a counterclaim. Now, procedurally, this is really complex. The more players you get, the more complex the case gets, and so. But on the other hand, it makes it means that there's only one trial rather than many trials. So the judge has to sort of weigh whether judicial economy, whether only having one trial means that it would be better to join in all of these claims and all of these co-defendants. So what the Karen Reed's attorney said was, we want leave from the court to submit a brief explaining legally why we want to do this and why it's permissible under the law, why the court has the authority to do it. So the other side got up and said, this is the first we've heard of this, and we don't know, because the attorney got up and said, we want to join Jennifer McCabe, Matt McCabe, the Alberts, the Brian Higgins, and listed off 5 or 6 people that they want to bring into the suit and file counterclaims against. And the judge finally, after there was a lot of wrangling back and forth, and the plaintiff's attorneys grumbling and mumbling an awful lot, the judge finally said to the defense, yes, please brief this. Tell me why in the law it is allowed, and why I have the authority to do it, and how procedurally, under the rules of civil procedure, it would work. So that's where they are with that, is the defense has said that they're going to file this brief with the court, explaining to the court why they can do this. If the judge agrees that procedurally it can happen, then they will file a motion to join all those parties. So the other alternative would be that they would have to file a separate suit against the Alberts, the McCabes, Brian Higgins, and then they would go back in and ask the court to join the two cases because they all arise out of the same set of facts, and it would be judicially efficient to try them as one trial. So that's, I think, what they're trying to do. But this is the first that we've actually heard that Karen Reed intends to bring a suit against them, and it essentially is for violation of civil rights. And it was funny because the judge, Karen Reed's, the attorneys for the O'Keeffes, the plaintiffs in the case, jumped up and said, "Oh no, you have to file civil rights actions in federal court. You can't file them in state court." And the judge looked at him like, "What planet are you on? Yes, you can file them in state court." So that we will see what happens. But it is the first time that she's clearly telegraphed that she intends to sue all of them individually, as well as some of the other people in the DA's office. I think she probably will sue Michael Morrissey as well. So, good question. We will wait to see what next develops there. Seasoned and savvy. What about the case in Kentucky, the Sheriff Mickey Steins shooting the judge? It's proving to be interesting if there's any truth to what may have been going on in chambers. Yeah, it's proving to be interesting for several reasons. First of all, what we know is that, and it's been out there on YouTube, that there was a deposition done with a woman who had been in prison and had had a relationship with the deputy who was involved in taking women into the judge's chambers. So for those of you that are unaware, there was a deputy sheriff who worked for Mickey Steins who was convicted of criminal charges because he was offering women in the jail release. A lot of them were sort of like, I could be released on an ankle monitor, but I don't have any money to pay for the monitoring fees. And so he was allowing those women to be released without ankle monitors in return for sexual favors. And he was using the judge's chambers as the place to collect those things. And Mickey Steins and the judge had been out to lunch. The sheriff was under a tremendous amount of pressure because he was being held responsible for what was going on in his jail that he didn't know about. And so they were taking depositions in the criminal case for the sheriff, the deputy. And one of the women that testified during those depositions said that she knew of women who were allowed to be released in return for favors. And she had been shown a video of the judge collecting those favors in his chamber. And that she knew the judge because she'd been in front of him before. So add on to that it appears that Mickey Steins was in the middle of a psychotic break at the time that this occurred. Some of the videos that have come out of him just following the incident show that he clearly was not in touch with reality at the time. The police were talking to him and he was not, he clearly was not in touch with reality. He had had a psychotic break. So there's a lot of questions around that. From the very beginning, his lawyer said, "There's way more to this story than anybody knows." And it appears that there is way more to the story. So we will wait to see what develops. But um, a- after having seen the videos of his arrest, of his behavior during his arrest, um, I would not be surprised for there to be a not guilty by reason of insanity or a guilty but insane plea in the near future. So we'll wait to see how that develops. States vary from place to place, and I don't know about Kentucky directly. Some states allow mental health as an affirmative defense, so not guilty by reason of insanity. But a lot of states, like my home state of Oregon, uh, have gone to a provision that allows someone to plead guilty but insane. Um, eh, I I I think it does make a difference between because in Oregon, with a guilty but insane um, plea, that person is committed to the state hospital for treatment. If at some time the person becomes competent and can understand the proceedings, then it's possible that they could serve some time in prison, depending upon the sentence and depending upon the person's mental condition. So we will wait to see how that works. Um, so who else has got? Oh, Tiff Knox, Karen Reed suing Massachusetts State Police, Canton Police, Yuri Buchanan, Michael Proctor, Brian and Nicole Albert, Matthew and Jennifer McCabe and Brian Higgins. Right. That was the list that her attorney read in court and said that they wanted to join uh, in the legal action. So, oh, and Trooper Tully. Good. Do you think Alex Murdaugh will get a new trial? I really doubt it. I know we have the whole issue of Miss Becky and whether or not she manipulated jurors, but I think that Judge Justice Toll, I think is her name, who actually did the inquiry into the jurors and Miss Becky's conduct. I think she did a very thorough job of questioning each juror and getting into whether or not that person was influenced in any way by what she heard from Miss Becky. So I don't think so. I think it's a last ditch effort on his part, but I really don't think that that there will be a new trial. And yes, I read Miss Becky's book, so you didn't have to. So yet again, took one for the team. So you're welcome. You are so welcome. My mom is doing very well. Thank you for asking. She just celebrated her 92nd birthday last week. I took her out for lunch, and my daughter came by and dropped in on her with flowers, and so she had some good visits and enjoyed her birthday. So, um, is it illegal for someone to lie in court filings? Um, yes and no. Um, yes, it is. It is definitely illegal for a lawyer to lie in court filings. And usually, court filing, you are swearing or affirming under penalty of perjury in a declaration or an affidavit. So, yes, it is. Does it happen? All the time. But it's not very widely enforced. And So I have a note I'm going to pop up here. I'm going to countermand Jen for a minute. Thank you, Polly O. You look great and your lashes are awesome. So I have to tell you, back when I lived in Idaho, it was harder to find people who did lashes. And I met this guy, and he was the absolute character, just an absolute character, and very funny, very gay guy. And I would go in and I would say, "Now, Clayton, I want you to remember I need less drag queen and more grandma." And every time I would walk out with lashes that looked like I was about to put on a drag show. So there were many times when people's laughter about my lashes were justified. But right now, I have a wonderful artist who does a really good job, and I appreciate greatly. And as you get older and hormone levels drop, your eyelashes disappear. And I hate it. So it's my guilty pleasure. Tiff Knox, we haven't heard from Trisha the trucker lately. I think she messaged me and told me that she was on a different route, maybe. But Trisha, if you're out there, check in with us, my friend. So, yes, Mama is 92. She lives in a assisted living about 5 minutes from my house. And several times a week, I run her little old dog down to visit her, and they have a little cuddle fest. And it's a good opportunity for me to pop in and see how she's doing. So I see her several times a week. She's doing very well. Medically, physically, she's pretty stable for somebody who's 92. So, yeah, longevity runs in my family. So you can count on me sticking around for a while. Let's see. How about last questions? Hi, Great Laker. How did the P. Diddy trial end? Is he in jail for the rest of his life? No, ma'am, he is not. Um, he um, he was convicted on a couple of the charges, and there is a prison sentence attached, but not for the rest of his life by any means. Somebody in the chat can remember for me because my memory is short on P. Diddy. To be honest, it really was not a case that I was that interested in. I wasn't that excited about it. I'm way more interested um, in YMW Melly uh, and that case. Mostly because he's been in custody for 5 years. His trial ended in a hung jury, and there's been so much shenanigans in in Georgia that it's a wonder that he hasn't been released yet because um, there's just way too much stuff going on with prosecutorial misconduct and all kinds of stuff. So, um, oh, Carol Renner says P. Diddy gets sentenced for the Mann Act charges in October. So we don't know yet whether what he's going to get sentenced to. I was thinking he hadn't been sentenced yet, but to be honest, they're all running together at this time of night. So, well, let's take some last questions. Hi, Barb Berturley. Is it free speech to talk about people on YouTube if they lie about who they are? It's free speech to talk about people on YouTube. And yeah, it is free speech to talk about them if they lie about who they are. It isn't defamation if it's true. So you don't run the risk of having somebody sue you for defamation if what you're saying is true and you can prove it. So if somebody lies on YouTube and lies about who they are, you have every right to call them out and to make their lies public. And it is free speech. So, there was something else I was going to say, and now it's slipped my mind. That's what happens when you get old and you have to have lashes. Carol Renner says she does her own lashes. I wish I were that talented. So, okay, last questions, guys. Last questions. I will look into the cases that you've asked me about for next week, so we will have some things to talk about. And in the meantime, uh, have a great rest of your week. Have a great weekend. And I want as always, thank you, Jennifer, for being the mod with the most. And thank you all for joining me tonight and for always being the best community and the best chat. And, we're small, but we're mighty. So thanks for joining me tonight. I will see you next week. Good night.